The lecturer of the University of Athens, Mr. Nikolopoulos, will now take the floor.
Για την πρόσκληση ως μη ειδικού για το κανονικό δίκαιο θα προέπει.
Very much for the invitation. I'll try to discuss the relations between canonical law and state law. Well, since the Roman times, there are various forms of rules, state rules, which coexist with canons for centuries. Until Leon the Wise and thereafter. And then there are canons concerning marriages with the heterodox. Then under the Ottoman Empire, we have the Nomocanon of Emmanuel Malaxos. We have and then we have other forms that are of cohabitation and marriage enshrined in decrees by the Kadis, the Turkish judge, and then Dimitrios Komatianos provides provisions securing the woman and the children in the absence of marriage. And then we have the Era 89, then Alexios Komnenos applies all this also to slaves. Well, there is a huge pluralism, in other words, during the Byzantine times, under the Ottoman occupation, etc. So the only time during which we have one single form of marriage is these days in the Greek state. This is binding for the Church and its pastoral approach. The Church, of course, does not or is not in a position to manage everything. That is why you have cases before the courts, cases which take years and years before the courts. So if we decoupled the mystery from the legal arrangements, the state legal arrangements, that would allow the Church to be more flexible. Then we have the bishop's permit. Ius Ignatius and St. Basil write and maintain that the explanation for the bishop's permit is that the faithful were not aware of all the issues, so the bishop should allow a marriage. For example, in Corfu, under the Venetians, licenses, marriage licenses, were issued on the basis of fake certificates, which again resulted in taking everything back to the secretary of the Holy See. So the prevalence of the Church has actually cancelled the powers of the mayor. Now, what are the obstacles, the impediments for marriage? All this became law of the state. It is part of the civil law until 1982-83, when all this was abolished. Today, the only obstacles is the existence of a previous marriage, bigamy, kinship, up to fourth degree, blood relations, blood kinship. Other obstacles concern kinship by marriage and adoption, step-father with a stepchild, step-parent with a stepchild. Some impediments, all other impediments were abolished. Then we have another thing. A fourth marriage is not allowed. According to the manuals, if there are 3 valid marriages, either civil or religious, a fourth one is not allowed. Is this correct? Yes. Am I right? Yes. Yesterday, we said that when what happens after a civil marriage. Can the child be baptized? Can he have a religious burial? Actually, one tendency is not to count a civil marriage among the three I just mentioned. So only the religious marriages would count. Religious marriages would make the fourth impossible. Then mixed marriages and religion. Article 1371 provides that in mixed marriages of an Orthodox with a heterodox or someone with other religion, these marriages must take place according to both religions. All theoreticians, despite that, claim that if the marriage takes place according to just one religion, then the marriage is valid. Actually, the Supreme Court in 1936 considered valid the marriage that was carried out only by a Latin Catholic priest. Then, of course, the ordination is an impediment, although the Ankara Council provided otherwise, and this lasted until the 26th. Let's see now divorce. We know that the Church reacted to the consensual divorce, but it was the case in Byzantine times. It was a known practice until Justinian, at least. The Church, of course, reacted even at that time. That's why Justinian abolished the practice. But it was there was pressure from the people, so it was reintroduced later, because they all admitted that coexistence in violence doesn't bring any good results. After the introduction of the consensual divorce, 1986, the bishops resolved these marriages. Actually, bishops and religious leaders encourage couples to, if they want to dissolve their marriage, to do it on a consensus basis. The other form of divorce applicable today is the divorce due to a serious rift in the relations between the couple. In the previous spirit of divorce, actually, the approach was different. Who is to be blamed? And there were quote-unquote punishments to the party that was to blame. Now, in the current modern spirit, the question is very simple. Is the marriage dead? Yes, then let's dissolve it. It doesn't mean, it doesn't lead anywhere to try to discuss who is to be blamed. That is why we had the practice of the so-called automatic divorce due to a rift, due to a breakup in the relations between the couple. And this required 4 years in the past, and now it only takes 2. Of course, it's not an automatic divorce, because with the times allowed by Greek justice, it might take years and years. Finally, we know that in the former legal framework, the bishop had some role to play. He was supposed, before the case would be heard by the court, he was supposed to try to conciliate the couple. All these provisions have been abolished, of course, but they have been replaced by other more modern approaches. Mediation, judicial mediation, and then who knows, in the future, maybe we have a more specialized family mediation or family courts. So these are just some elements concerning the formalities of marriage. The Byzantine system was pluralistic. As I said, the same is the case today. We have various forms of cohabitation. Others are accepted, others not. Have a civil marriage, religious marriage, free cohabitation, and the pact, the cohabitation pact, the civil partnership agreement. In this case, this is the cohabitation, the partnership between two persons of different sex. In some legal provisions, Some legal provisions concern the alimony rights after divorce. This actually depends on whether you live with another partner or not. There are provisions for family violence, medical interventions, money laundering. There are provisions on everything. Pensions, for example, the time of marriage, the duration of the marriage required for someone to be entitled to the pension of the defunct. The Supreme Courts have diverging opinions on these. Then courts do not recognize compensation for mental suffering to the partner in the case of the death of the other partner. Then assisted reproduction, recognition of children, wills. They are considered against morality only when the will of the defunct shows deep contempt to the persons of his immediate environment. Anyway, all this led to the approval, the introduction of the Civil Partnership Agreement, PAC, a formal framework totally different to marriage. This is equivalent to the concept of concubinate in Byzantine times. And of course, concubinate is differentiated from prostitution. St. Nicodemus, in his Pedalion, says the prostitute is different to the concubine because the prostitute has relations with more than one person. There are also rules whereby explanations are provided as to the concubine who is known to live, to cohabitate with a man without being married. When the discussion started on the Civil Partnership Agreement, the Holy Synod made a decision on March 17, 2008, according to which, quote, the Church accepts the religious marriage and considers prostitution any relation outside marriage and is not in a position to concur to the proposed bill on the Civil Partnership Agreement, which legitimates very heavy moral crimes, as this will be a disaster and will undermine the moral foundations of the Greek society. Well, things are different, of course, today. Let us see now the law. You need a notary public. The act is entered in the civil register in 4 easy forms with a joint agreement, unilateral termination, etc., etc. All this must be entered in at the civil register. This provision has been criticized. It is considered not as so moral, because supposedly one can enter into another marriage while he's married to another person. Of course, the PAC is an obstacle for another marriage, the CAP, the Civil Partnership Agreement. No, sorry, marriage is an obstacle for a Civil Partnership Agreement, but not vice versa. Other provisions introduce inheritance rights, legitimate inheritance, alimony only when this has been agreed upon by the couple, and then there is an article which emulates another rule concerning marriage about the recognition of the children. Question without microphone. If a religious marriage takes place, then the Civil Partnership Agreement is terminated and the marriage is valid. Then tax and pensions, this has not been covered yet. After the introduction of this law, but that was 5 years ago, we realized that very few civil partnership agreements have been made. The people have not embraced this. And this, let me also say that it concerns persons of a different sex. Homosexuals, of course, exerted pressure on that. Remember the marriages in Tilos in 2008. The prosecutor of the area asked for these marriages not to be recognized, but on the basis of other provisions of the family law, we see that the law takes it for granted that it concerns people of different persons of different sexes. All experts agree on that, with the exception of one colleague. Then, homosexual couples, Valianatos and others, resorted to the Court of Human Rights in Strasbourg, and they were vindicated. The decision of the court in Strasbourg vindicated these homosexual couples. We'll come back to that. The views of the Greek state were not admitted. The Greek state maintained that the civil partnership agreement was introduced to protect children and to regulate economic relations. The court in Strasbourg, also in other rulings, had decreed that homosexual partnerships also can be subjected to the rules applicable to civil partnership agreements, and that these homosexual relations and cohabitations must be recognized as such. Now, today, we realize that CPA was introduced for heterosexual couples and it has not been embraced. And then homosexual couples request CPAs and it's not granted by the state. Things change, less children born, less marriages. We have issues pertaining to assisted reproduction, etc., etc. This raises a huge amount of issues, pastoral, civil, etc. Then we have new technologies, as I said, for assisted reproduction. These things, of course, cannot have been provided in the canons of the Church. These things did not exist in the past. Fertilization of ovaries, etc., with sperm by a third person, by a donor. Surrogate mothers. This is or post-mortem artificial insemination, etc., etc. The Church only accepts one sort of insemination, and the question is here whether this is the real conscience of the Church. Could it not be then introduced as a rule, providing also penance for all those who use other sorts of insemination? The question is, again, can we and should we introduce new canons? Should we revise older ones? What about the Panorthodox, the forthcoming Panorthodox Council? Does it have anything to say on this? In Chambézy, we had started discussing all this. These are modern challenges that can and should be discussed at the Panorthodox in all directions, and we are open, we should be open. Revise, introduce new